Hello and welcome to Legally Speaking with me, Tarun Nangia. This is the part two of our show titled Justice Suryakant as Chief Justice of India, Opportunities and Suggestions. And I have two very eminent panelists joining me today. Indeed, I'm pleased to welcome Justice Mukul Mudgal. He served as Chief Justice, Punjab Haryana High Court. He's a leading sports arbitrator. He's also serves as the head of the FIFA Governance Committee and Review Committee. A very popular judge, also someone who was one of the first 5, 7 episodes, first guests when I started the show more than a decade ago. And it is always a pleasure to have you again on the show.
Thank you for your kind words.
And I have with me Advocate Sri Venkatesh, who practices at the Supreme Court of India, also does a lot of electricity litigation, and also at the Delhi High Court. Good to see you, Venkatesh, and thank you for your time.
Thank you so much, Tarun.
At the outset, uh, they say, sir, that you're an encyclopedia on the system. And in a sense, you served also a lot of time in the Punjab Haryana High Court as Chief Justice. Maybe I think Justice Suryakant would have been there serving those days.
Okay.
And of course, then you're a Delhiite, you served in Delhi for a long time. And now you're seeing Justice Suryakant being elevated as the Chief Justice of India. The first few words before we begin our conversation.
Well, I think first, congratulations, and then second, that it's a huge opportunity to do something about the system, which remains still requires a lot of attention. That's all I can say, because my experience, I must confess, is confined to 25 years of practice in Supreme Court, but which ended in 1998 with my elevation. And then after retirement, I did not want to practice. So I must tell you that. Okay.
Okay. So now we delve into where some opportunities and some suggestions as to what can be done. Advocate Sri Venkatesh, would you like to come in before we go to Justice Mudgal and get his words of wisdom on this issue?
Thank you, Tarun. I was reading about Justice Suryakant. Of course, I've only appeared before him when he came to the Honorable Supreme Court, and looking at his career trajectory from where it started from Hisar, and now he sits as the 53rd Chief Justice of India. I think one phrase which could encapsulate this whole journey that he's an embodiment of rising through the ranks. He has seen judiciary at all levels. He has seen practice at all levels, and finally he gets to, lead the judiciary in the direction that he wishes to be the most appropriate. So therefore, this is a story of celebration, and my congratulations to Justice Suryakant, and I hope that his tenure is as fruitful as his tenure has been so far as a judge of the Supreme Court.
Thank you. Thank you for that opening comment. Justice Mudgal, we are seeing pendency in Supreme Court at 90,000 cases, roughly about reaching 90,000. The country's pendency is about 6 crore cases. So do you think there is a daunting challenge that the chief has, and any inputs that you would like to give because you've dealt with this as Chief Justice?
Look, I think there should be a system of listing. I've talked to some advocates on record, and their suggestions are that there should be special benches for listing of non-miscellaneous matters for final disposal on Monday and Friday afternoon. Time to be fixed for each matter. My comment is, when you ask for early hearing, you indicate the time you will take to finish. Yes.
Okay.
Notwithstanding the judge's questions and all, but you have to give a time. I take only this much time. Please hear me early. That's one. Second, that there should be separate benches to hear single judges benches to hear bail and transfer petitions. And previously bail matters were heard in chamber during my practice time at between 1 and 2. There used to be a chamber judge. Then batch matters to be identified, that's the usual, and taken up for hearing as regular hearing matters on Wednesdays and Thursdays. and compulsory mediation in family and matrimonial disputes after notice was issued.
Okay. Okay. And I would like to in specific ask you, if the Supreme Court has this pendency of say 80, 85, close to 90,000 touching now, what can be done so that that is expeditiously sort of, disposed of? Uh, uh, like I think Justice Suryakant said that he will dispose of one matter and many connected matters will get
Yeah.
disposed of in that way, so he'll identify those matters where there are 50, 60, 80 connected matters. Any other suggestions that you have on that account?
Look, I believe mentioning takes away a lot of time. I think Mr. Venkatesh will perhaps confirm that. My suggestion is first one is to follow the practice of Justice P.N. Bhagwati, who used to finish the court and take up mentioning at 4:05 every day. That I have also suggested to him otherwise. But this would a leave the Chief Justice open for hearing matters throughout the day. Otherwise, some mentionings are bitterly fought, and there may be reasons for it. But it's better that the mentioning is taken away from the court. It'll be convenient to lawyers also, let me tell you, because a lawyer who is asked to mention a matter may have item number one in some other court, and he'll find it difficult to handle both. So you start at 4:05. For a quick judge like Justice Suryakant, I don't think it'll take more than 20-25 minutes to for the matters. And
Okay.
one question we ask, what is the urgency? Is there an eviction tomorrow? That kind of a thing. What is the date of the High Court judgment? These are important matters for this thing. Otherwise, you wake up after 3 months of the High Court judgment and want an urgent. I think that should be discouraged.
Point very well taken. I'll go to Advocate Sri Venkatesh. If you see pendency pan India, also there is the issue of artificial intelligence now, which Justice Suryakant has welcomed, but he also said that humans will have to have the final say, but you can take help of AI. He also says people know that it is used in drafting these days, but he says a human at the top should be the final arbiter of justice, not machines. Any suggestions that you have for Justice Suryakant?
Tarun, I think pendency is also a reflection of the size and scale of our country. See, we have 1.4 billion people, five, I think, if the consensus is held today. So naturally, if there is a SLP jurisdiction available before the Honorable Supreme Court, I don't think parties are letting go of that remedy. Therefore, pendency is not, it does not something which worries me. But what does, as a suggestion, if I may say so, the justice dispensation should actually be predictable and certain. That is an aspect, I think, where Justice Suryakant may perhaps consider bringing out certain reforms. Now, when I say this, what I essentially mean is what Justice Mudgal also alluded to, that the process of listing of a matter and the process of dates being given, which ultimately end up disappearing because the benches change and the boards change, this system has to be given some thought to, because ultimately, when you are before the Honorable Supreme Court and if notice is issued in your matter, you are there for your scope of relief is very limited. And therefore, there should be some amount of certainty when those matters come back to the court. That is one starting point, which I find as a practitioner in Honorable Supreme Court, I find that to be quite a challenge. Notice does get issued, but the matter somehow loses track, and you have to mention 3 or 4 times sometimes to bring the matter back to court. That's one issue that I find. The second issue is another aspect which the Honorable Supreme Court is grappling with, which is family disputes, as Justice Mudgal referred to. And in fact, I remember we had done a show on Justice Suryakant's vision of mediation. Now, mediation, if it is being implemented at a mass level, then surely when an SLP is filed before the Honorable Supreme Court, and I'm taking the cue from what Justice Mudgal said, the moment notice is issued, even if parties are not appearing, the matter should be sent to mediation, so that at least there is a large likelihood of parties settling this out in mediation, then coming back to court. Now, currently the process is that, look, once both parties appear, counters are filed, then one of them will reluctantly say, look, I want mediation. Then the bench would refer the matter to mediation. I mean, this would take about 2 to 3 hearings. So imagine the judicial time that is getting occupied in sending the matter to mediation. So I think this could be cut short on the first day itself. perhaps we may be able to reduce the pendency or the workload on the judges, because pendency is ultimately a function of how much work they do. And lastly, on artificial intelligence, it is actually no secret today that at least the lawyer community is widely using artificial intelligence when it comes to their drafting. I hope they're not using it for research. For drafting, at least this is something which is very rampant. Therefore, we have something called an office report which is generated, which I think I spoke about to you when Justice Gawai was resuming office. That office report till date is very mechanical in terms of capturing what the essence of a matter is. Now, if the office report becomes a little more comprehensive and is able to tell whether the point of law which is being raised in the SLP has been decided in some other matter, or at least has been considered in some other matter, the judgments so cited are they still relevant or not, and give a brief overview of facts. If that is prepared by deploying artificial intelligence, I can bet that this will become a great assistance to the bench in understanding what is the scope of the SLP when it comes on a Monday and Friday, because they have to really read about 70 or 80 briefs in those 2 days. It'll help them understand the scope of work. So it'll be faster in terms of coming to the heart or the fulcrum of the dispute, and it'll help with the lawyers as well, because the lawyers would also know where the pitfalls lie in their case, and they will come prepared to answer those specific questions, so that perhaps their case is entertained by the court. So these three areas, if the judiciary looks at more minutely, then I feel the pendency, notwithstanding the number of cases which may otherwise seem quite alarming, the justice administration system would get more efficient. And I think therefore, solving the problem of citizenry in terms of approaching the Supreme Court and seeking relief. Last point, because I thought I should add this today. See, I have seen now, I've been following this Delhi pollution crisis for the last 8-9 years. It happens every year. Now, there is a PIL which is pending. That PIL does get taken up at some point in the year. And then the PIL, some orders are passed and some directions are issued. See, ultimately, this plane in which almost 7.5, 8 crore people live, which are suffering through pollution. I think a permanent courtroom, a permanent bench should be assigned, which should hear this issue, who should hear the matter of this pollution before September actually hits, and monitor the progress during the months of October, November, and December. I think this is something which, with great respect, the Honorable Supreme Court, while all the right intentions that they want to curtail this pollution, but because we are taking stock of the situation post facto, as opposed to before the situation actually arises. If this can be done, at least for this period that we all live in, then at least this 7 or 8 crore people who are suffering through pollution every year, starting from September right up to December, this problem can also perhaps be addressed. These are some suggestions that I would have for Justice Suryakant.
Thank you.
Venkatesh has given excellent suggestions. I would like to add one or two things there. You see, this after notice, I remember when I was practicing, matter would come on that date. A date was given while issuing notice. If that practice is followed. Secondly, I believe that Mr. Venkatesh would perhaps confirm that sometimes the matters get deleted without notice to the party. Please remember, in a Supreme Court matter, the client, if he can afford it, or even if he can't afford it, would like to come and attend the hearing. If he has traveled all this way, imagine his heartache, not being taken up. So at these, when notice is issued, it should be indicated on what day after notice it will be listed.
Point very well taken. Any reflections from the Punjab Haryana High Court times? Any anecdotes that you would like to share?
Well, I can tell you, Justice Suryakant was a member of the full bench. There were about, let's say, 50 matters pending in the High Court, and depending on those outcomes for full bench hearing, about 1,000 or so were pending before the single judges and all. They were held on hold till the full bench decided. I decided to take up these matters in 2 weeks, 2 fixed weeks, giving adequate notice, saying no adjournments, the matter will be taken up. And Justice Suryakant was a part of my bench and we resolved every pending full matter, and he wrote a majority of those judgments.
Oh, this is Punjab Haryana High Court 15 years ago. This glad to know that, knowing his nature and knowing in a sense his hardworking demeanor and also his commitment to the profession. What are your good wishes for him for his tenure of 16 months?
Well, he should be remembered as a kind judge, as a compassionate judge, and a firm judge when it is needed. Justice without compassion is useless. I mean, that's the view I've always taken as a lawyer and, well, as a judge also.
Thank you. And Advocate Sri Venkatesh, your good wishes for Justice Suryakant.
I can only wish him all the very best for the tenure that is ahead of him. Of course, we live in very, very divisive times, and there are going to be a lot of controversial issues being raised before him. I hope he maintains his calm and composure as he usually has done so far. And he's been, a delight to appear before and argue. And I hope that that continues in his tenure to come.
I have no doubt that he will continue to maintain his composure. I can tell you that. And yet firmly deal with, I would say, is overstatement of cases, And I wish him all the best.
Thank you, Justice Mudgal, for making time for this special show on Justice Suryakant. Thank you, Advocate Sri Venkatesh. Of course, we'll invite you again when his first big judgment comes, or he takes the first big decision on the administrative side, may also be the appointment side. All of that will be known in the coming few weeks. But that's it for now. I'd like to thank you for your time, and thank you, viewers, for tuning in. Thank you so very much.
Okay. Thank you. Nice being with you, Tarun and Mr. Venkatesh.
Thank you.
Thank you, sir. Pleasure. Thank you.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.